Good day, colleagues. My name is Possible, and we are coming to discuss land law. Land law. In our previous discussion, we look at common law freehold. Common law freehold. So far, we have looked at allodial title, which is the ultimate title or the ultimate interest in land. And then we have looked at, from the allodial title, we have looked at the common law freehold. We have also looked at the customary law freehold. We have analyzed them one after the other. Today, we are going to look at usufructuary interest. Usufructuary interest. Usufructuary interest. That is what we are going to look at. So make sure to grab your pen, pick your Land Act 2020 at 1036. Pick your Land Act so that whatsoever we are going to discuss, you could make reference to them. In fact, we are on interest in land part 2. Interest in land part 2, which is the continuation of the part 1. The part 1, we have discussed 3 interests, which is the allodial title, customary law freehold, and the common law freehold. Part 2, we are going to discuss 3, the additional 3. So make sure to be available. What are these 3? By the end of this discussion, you should be able to discuss the usufructuary interest with relevant authorities. So we'll be starting with usufructuary interest. Usufructuary interest. And then after that, we also analyze leasehold interest, and then we talk about customary tenancy. So usufructuary interest. But before then, let us pay respect to the Land Act 2020 at 1036, because it has done us much good than harm. Let us pay 10 to 15 seconds respect to it. All right, so welcome back. And then we are moving straight into our lesson. So part 2, we are going to focus on usufructuary interest, leasehold interest, and customary tenancies. So make sure to grab your pen and write or jot something down. Remember that these 3 are already tackled. Allodial title is tackled, common law freehold is tackled, customary law freehold is tackled. So we are left with usufructuary interest, leasehold interest, and customary tenancy. So be available to learn these. So let us move on. Registrable interest in Ghana. We have looked at all these ones. We have analyzed them one after the other. The registrable interest, paying attention to section 81. It is not section 880. No, it is not 810. Section 81 or section 1 of the Land Act. So quickly, we are on the usufructuary interest. Let us set the ball rolling. When we talk about usufructuary interest, the first thing to come into your mind is section 5 of the Land Act 2020 at 1036. So as we always do, let us pay attention to it and finish reading it before we start with our lesson. Grab your Land Act whilst we read it together. Usufructuary interest, section 5. The title is usufructuary interest. Subsection 1. Usufruct is an interest in land which is acquired in the exercise of an inherent right. The underlying word is inherent. Inherent right by a subject. The underlying word is a subject or a member, underline this, a member of a stool or skin or family or clan which holds the allodial title through the development of an unappropriated, so underline, development of an unappropriated portion. So underline it. So underline inherent, underline subject or member, underline development of an unappropriated portion of land, of the stool or skin or family or clan, or by virtue of an express grant, or, so look at it, I have just projected it. Usufruct is an interest in land which is acquired in the exercise of an inherent right. Inherent right is underlined. Inherent right by a subject, and a subject is underlined, or a member is underlined, of a stool or skin or family or clan which holds the allodial title through the development of an unappropriated portion. Development of an unappropriated portion is underlined, of the land, of the stool or skin or family or clan, or by virtue of an express grant, or B, acquired through settlement for a period of not less than 50 years. A period of, so you can underline, not less than 50 years. It means that it could be more. It could be more. So equal to, greater than or equal to 50 years. Don't forget. For a period of not less than 50 years, with the permission of the holder of an allodial title by a non-indigene or group of non-indigenes, or the descendants of the non-indigene or group of non-indigenes, except where the settlement is on agreed terms, and C, inheritable and alienable. Inheritable and alienable. Inheritable and alienable. So that is it. Inheritable or alienable. 2, where alienation of the usufruct is to a person. 2. So subsection 2, section 5, subsection 2, where alienation of the usufruct is to a person who is not a member of the stool. It means that from here going, the first one we read, section 1 is talking about someone who is a member or a subject of a stool. It means that the person comes from the area. The subsection 2 is talking about someone who is not from the area. So you should understand it. Or subsection 2A, subsection where alienation of the usufruct is to a person who A, is not a member, is not a member of the stool or skin or clan or family which holds the allodial title, or B, is not a non-indigene or from the group of non-indigenes who hold the usufructuary interest as provided in paragraph B of subsection 1 in the land in respect of which the usufruct is to be alienated. The alienation is subject to the written consent of the stool or skin or clan or family or group and the performance of established customary obligations. That is section 5. We have finished reading all. So whilst we are going, be following it so that you'll be understanding the Land Act, because that is how we are going to discuss it. We are discussing them section by section. So usufructuary interest. Now you shouldn't forget that we have looked at the first mode of acquisition. The first mode of usufructuary interest. Usufructuary interest. And then we define it. We got to know that we are saying that a usufruct is an interest in land which is acquired in the exercise of an inherent right. It is an inherent right. It is an inherent. Why do we say inherent right? It is an inherent right because a person who comes from a particular society, per the cases of Ohemen versus AJ, when we're analyzing it, we realize that because the person is serving or the person is giving respect or paying allegiance to the stool or the skin, that person has rights over the land, has rights over the unoccupied portion of the land, and then to reduce it into his lawful possession. Don't forget, under Ohemen versus AJ. So if that be the case, we are saying that a usufruct, get to know, allodia is the supreme. Allodia, customary law freehold. You are going to buy it based on customary law processes. Common law freehold, you're going to buy it based on customary law processes, right? Or you're going to transact it. You're going to involve yourself in transaction. You're going to involve yourself in transaction. You're going to involve yourself in transaction. That is the customary law and then common law. By usufructuary interest, we are saying that it is an inherent right. It is an inherent right. We all belong to a society. You belong to a society. I belong to a society. So the society you belong to, there is a stool. That particular stool, you pay allegiance to that stool. You are under the stool. You are indigene or indigenous person. You are a member of the community. You go for communal labor. You do what this is. So you are a member of the community. And then because of your allegiance to the stool, all the lands that belongs to the stool, the areas or the portions that are unoccupied by anyone, you could go there, settle down, make sure to clear the plants and the trees and everything, and reduce them to your lawful possession. It becomes your own. It will become your own. That is what is called usufructuary interest. For usufructuary interest, the portion of the land that is unoccupied by anyone, you make sure to clear it, and then you reduce it to your lawful possession. You clear it, you make sure to decorate the place, and then it becomes your abode, or your the place that you are going to stay. That is usufructuary interest. That's all about usufructuary interest. And then we are saying that the situation whereby someone who is not a member of the allodia title or is not a member of the community, someone who is not a member of the stool, that is subsection 2. So subsection 1 is talking about someone who is a member of the stool. Understand it too. Usufructuary interest could be categorized into two. Number 1, someone who is a member of the stool. Number 2, someone who is not a member of the stool. All outside people who are foreigners. That one is being addressed by a different thing. I hope you are getting it. So understand usufructuary interest. Then we are done with it. If you understand it up to this point, then we are good to go. That is how it is. So the second mode of acquiring the usufruct. So this is the first mode. If you look at it carefully, you see the first mode. This interest in land can be acquired by a subject or a member of a stool, skin, a clan, family, or an individual or groups which hold the allodia title. So first mode of acquiring the usufruct is by a subject or a member of a stool, a skin, a clan, a family, or an individual or a group which holds the allodia title. So under that one, that is what we mean by that. So such a person acquiring the usufruct must exercise or must be exercising his inherent right. What is that inherent right? Inherent right that you have been born into that society. You have been born into that stool. You have been born into that skin. So automatically you become part. So you are exercising your inherent rights. The inherent right that you are paying allegiance to the stool, you are paying allegiance to the skin, you are paying allegiance to the family. So the land, you could also take part of it. Specifically, the unappropriated portion, the unappropriated or unoccupied, the portion that has not been appropriated to anyone, the portion that no one is owing it as it stands now. It doesn't mean that it doesn't have owner, but the portion that no one is living on it, the portion that is lying empty, you could reduce it to your lawful possession. So such a person acquiring the usufruct must be exercising his inherent right as a subject to develop an unappropriated portion of the land of stool, or the land of stool, skin, or family, or clan land. Or such a person acquiring the usufruct must have acquired the interest through an express grant. It could also be that the person who is acquiring the usufruct, it is the stool that is given to the person because the person is a member of the society, and probably he or she is not getting a place to sleep or getting a place to stay. So the stool is given to a subject. So either going to settle on it without any express grant or through an express grant. That is a member or a subject of the stool. The second mode of acquiring the usufruct, is according to subsection 2, where alienation of the usufruct is to a person who A, is not a member of the stool or skin or clan or family which holds the allodial tithe, or is not a non-indigene. This grammar, it is a typographical error. The framers of the law, they committed mistake here. So that is how it is. So the second side is the second mode of acquiring the usufruct. The second mode of acquiring the usufruct is as specified in section 1b. Section 1b, acquiring through settlement for a period of not less than 50. So the second mode is the section 5 1b. Acquiring through settlement for a period of not less than 50 years with the permission of the holder of an allodial title by a non-indigene or group of non-indigenes, or the descendants of the non-indigene or group of non-indigenes, except where the settlement is on agreed terms. So the second mode is the usufruct is whereby someone is going to settle on the land for a period of not less than 50 years. So acquired in the exercise of an inherent right. B says that acquired through settlement for a period of not less than 50 years with the permission of the holder of an allodial title by a non-indigene. So if you are not from the town, if you are not part of the stool, and then the stool gives you the land, gives you the permission, the allodial title, the stool, the allodial title holders, gives you the permission once you are not a member of the society, but they give you a permission to stay on the land for more than 50 years and above. For 50 years and above, then automatically the land becomes yours. So acquired through settlement for a period of not less than 50 years with the permission of the holder of an allodial title by a non-indigene or a group of non-indigenes, or the descendants of the non-indigene or group of the non-indigenes, except where the settlement is on agreed terms. So except the situation whereby the allodial title holders are saying that, well, stay on the land, but when you die, we will sack your children from the land and then we take our land back. That one, the person can stay on it for 70 years, but there's an agreed term. The agreed term is that after When after you are deaf, your children are going to be sacked from the land. So that one is except there's an agreed term. That is the B section. If not, and then you just grant it to the non-indigenous, someone who is not a member of the society, then it means that it is moving away to the person. However, there is different procedure. There is different procedure for alienation of usufructuary interest depending on whether the holder is an indigene or a stranger. So when we are talking about alienation of usufructuary interest, if you're a usufruct, you go and you go and stay on a land for some time and then you become the owner, or you are not a member of the society, right? You are not a member of the society. The way of alienation means selling it or giving it to different person. That one has different approach. So we have to get to know, if you're a stranger, that one is different. If you are an indigene, that one is different. So let us analyze these two principles. If you are a member of the society, how is the alienation going to be done? How are you going to transfer it or sell it to different person? If you're a stranger, how is it going to be done? So let's continue. By the dictates of section 5 subsection 2 of the Act 1036, when the holder of the usufructuary interest is a non-indigene, that means the person is not a member of the stool or skin, such a person could only alienate the land to another stranger with the written consent of the stool, skin, clan, or family that holds the allodial title, and also upon the performance of the established customary obligations. So if you are a foreigner, if you're a stranger, if you are not a member, if you are non-indigene, and then we gave you a place to stay, and then you want to sell the land to someone, then automatically it must be in a written consent. You have to write to the allodial title, or the allodial title holder has to give you a written consent, permission to sell it. So that is how it is. We are still on the section 5 subsection 2. It reads as follows. We are going to look at it again. Section 5 subsection 2. We are going to analyze it again. A. So let me start it. Where alienation of the usufruct is to a person who is not a member of the stool or skin or clan or family which holds the allodial title, or is not a non-indigene, or from the group of non-indigenes who hold the usufructuary interest as provided in paragraph B of subsection 1 in the land in respect of which the usufruct is to be alienated, the alienation is subject to the written consent of the stool or skin or clan or family or group and the performance of established customary obligations. So it means that I think I've explained everything. If you are not a member of the society and then you want to alienate, do not forget. B says that it's not a non. Look at the B. It's not a non-indigene. Please, the framers committed a mistake. It's not an indigene. That is how it's supposed to be. The person is not an indigene. Is not an indigene. That means the person is not a member of the society. So don't forget this correction. So note the use of the express non-indigenes under section 5(2)(b) is a typographical error and is supposed to rather read as not an indigene. So that is how it is. You should bear that one in mind. Let us quickly analyze the case of Mansu and Aboye, 1982 to 83 Ghana Law Reports, and then what Aban J.A. said. What Aban J.A. said. Aban J.A., what he said. So let me quickly invite you to read with me the case of Mansu versus Aboye. The plaintiff, as a usufructuary owner, cannot be ousted from the land by the co-defendant in an arbitrary manner. Some of the cardinal incidents of the usufructuary interest are that the usufructuary has exclusive possession and enjoyment of his portion of land, and he cannot capriciously be divested of this interest by the stool. Neither can the stool alienate that portion of land to any other person without the prior consent and concurrence of the usufructuary owner. So it means that once you are a usufruct and you are living on the land, the stool cannot sell the land to anyone without your consent. Without your consent. Let's continue with the case. The allodia owner, without the permission of the usufructuary owner, has no right to the economic trees, any land which is in the possession and control of the usufructuary owner, whether those economic trees were cultivated or grew on the said land without the intervention of human labor. So, if you are a allodia title holder, or if you are allodia owner, you can't just go to the land and say that, yes, I'm the allodia owner, so there is coconut, I'm coming to pluck some. There is pineapple, I'm coming to pluck some. There is orange, I'm coming. No. You can't just go there like that. It belongs to the usufruct, the usufructuary owner. The usufruct, it belongs to the usufruct. That is how it is. So understand it once and for all. Let me quickly invite you to read with me the case of Ohemen versus AJ, Ohemen versus AJ, Ohemen versus AJ, Ohemen versus AJ, West Africa Law Report. That is what we are going to look at. Again, I told you we will come back. The stool holds the absolute title in the land as trustee to and on behalf of its subjects, and subjects are entitled to the beneficial interest or usufruct thereof and have to serve the stool. So in return of serving the stool, the members of the community are also having the right to enjoy the unappropriated or the unoccupied portion of the land. So don't forget this. Let's continue with the case. Each individual or family is regarded in the broad sense as the owner of so much of the land as it is able by its industry or by industry of its ancestors to reduce into the lawful possession and control. So each individual or each family member who is paying allegiance to the stool could make sure to find a place which is unoccupied, and then they reduce it into a lawful possession. Ohemen versus AJ continues. The area of the land so reduces into lawful possession of individual or family, and over which he or they exercise a usufructuary right, usually called his property. It cannot saved with the express consent of the family or individual be disposed of by the stool. So without the express consent of the family or the individual who are holding usufructuary interest, without those consents, the allodia title holder or the allodia tithe cannot dispose this lands. So the individual or family may assign or dispose of his interest in the land to another subject of the stool, and the land may be sold in execution of a decree against the individual or in the family, as the case may be, without the consent of the stool. Again, we are trying to say that the person, the usufruct, could also dispose it off to another member of the stool. Remember, another member of the stool. Another member of the stool. He can freely sell it out to any member. Again, in case there is a court case against the usufruct, and then the judgment of the court is that the land is supposed to be sold in order to settle a particular debt, then the land, so it shall be. The allodial title holder cannot interfere, because the court will see the usufruct to be the owner of that portion of the land. So it is fairly established. But he may not dispose of the stools absolute. We are reading it. But he may not dispose of the stools absolute ownership in it to strangers without the consent and concurrence of the stool. So if the usufruct is selling the land to strangers, he must seek permission from the allodial title holders. Let us quickly analyze the case of Nokwe Tete versus Mam and Ano, 1959 Ghana Law Report, page 368. Nokwe Tete versus Mam and Ano. By customary law, a stool cannot make a valid grant of any portion of its land on which there exists economic tree like mango and cashew. This is a well-established custom which is based upon another very sound customary law, namely that any subject of a stool is entitled to occupy a vacant portion of the stool land and to become the owner of the usufruct thereof. So if it is vacant, no one is staying on it, I can come there and stay on it. Let's continue. His occupation and possession may be by cultivating it in one form or another, by building on it, or using it in any other way in which an owner would use his land. So you can build on it, you can farm on it, you can do anything, you can rear animals on it. A subject in such possession may alienate that possessory title of his either to another subject or to stranger. I repeat myself, the same thing has happened in this case. Or he may lease it, so long as such alienation or lease carries with it the obligation to recognize the allodial ownership of the stool. By custom, a stool cannot alienate its absolute title in such a portion of the stool land without reference to the subject or grantee in possession. So if a subject is staying on the land, the stool cannot just go ahead and then alienate the portion of the land. In conclusion, what have we learned under usufructuary interest? We have seen that usufructuary interest could be done by a member of a stool, which is indigent, and then it could also be done by non-indigent. For indigent, the indigent will just go and settle on it and then stay on it, and so shall it becomes his property. He can alienate it to another indigent, and he can also alienate it to a stranger, but subject to consent and concurrence of the allodial title holder. Again, subsection 2 of section 5, it talks about the situation whereby, in fact, section 5, subsection 1b, talks about the situation whereby non-indigent will settle on the land 50 years and above, except there is an agreed terms. If not 50 years and above, it becomes their property. It becomes their property. So that is how it is. And then they could alienate it to a member of the stool or a stranger subject to consent, written consent or concurrence of the allodial title holder. So in all, usufruct is interest in land which is acquired in the exercise of an inherent right. Exercise of an inherent right. What is the inherent right? The inherent right is that you are part of the stool. You are part of the stool. Acquired in the exercise of an inherent right by a subject or a member of a stool or skin or family or clan, which holds the allodial title through the development of an unappropriated portion of the land, of the stool or skin or family or clan, or by virtue of an express grant, or acquired through settlement for a period of not less than 50 years with the permission of the holder of an allodial title by a non-indigent, by a stranger or non-indigent, or a group of strangers or non-indigent, or the descendants of strangers or non-indigent, or group of non-indigents or strangers, except where the settlement is on agreed terms. And C, it is inheritable and alienable. It could be inherited, and it could also be alienated. This marks the end of usufructuary interest in land. In our next discussion, we are going to look at leasehold interest. Leasehold interest. Leasehold interest. Leasehold interest. So prepare yourself and be willing to learn with us. Leasehold interest. Leasehold interest. Leasehold interest. So that is what we are going to look at next. Once again, my name is Possible, and I've been your tutor up to now. Until we meet again another time, I will say bye-bye for now. Bye.